Hi, my name is Mike Greiner. I'm a bankruptcy attorney here at the Financial Law Group located in Warren, Michigan. Our website is financiallawgroup.com, and my phone number is 586-693-2000. We do offer free consultations for people who are interested in this process. I'm here to talk to you today, though, about the process of Chapter 7 bankruptcy a little bit. Now, something that a lot of people are concerned about is what's going to happen as they go through this process. And let me just tell you a little bit about the basic steps that's going to happen. The first thing is you'll meet with me or another bankruptcy attorney, and we will file your case. It's a matter of filling out the forms and getting them ready to be filed with the bankruptcy court. That's usually the type of thing that you will do with a bankruptcy attorney. Now, before the case can actually be filed, you're required to do a certain credit counseling. The credit counseling can usually be done over the phone or over the internet, and in our case at least, we'll set you up with a credit counseling company that will take care of that for you. The cost of that oftentimes is $40 to $50, and in our case we actually include that in the cost that we quote you. Once you've completed the first credit counseling, we file the case. After the case has been filed, you have a couple things that you need to do. The first one is you need to do a second set of credit counseling. That is a requirement, and if you do not do that, your case will be dismissed and you will not receive your discharge. It can be very expensive to reopen your case and to get your case started back up again to get your discharge. So I definitely suggest that people do that second set of credit counseling relatively soon after they've filed their case. You have a little bit of time, but don't let time pass. That's the first thing. The second thing is there's a hearing. It's called the first meeting of creditors. Typically that hearing is held about 6 weeks after you filed your case. Usually you will not see a judge. Usually you will just see someone called a trustee. The trustee is an attorney appointed by the court to represent your creditors. That attorney gets to ask you questions, really to verify the information in your bankruptcy petition. If your petition is properly prepared by a bankruptcy attorney, usually it'll go pretty smoothly. Before the meeting, there is a requirement that certain documents will have been sent to the trustee. Typically, in a bankruptcy case that we're handling, we will take care of sending those documents ahead of time, and they include things like tax returns, pay stubs, and real estate documents and titles to vehicles that you have a loan on. Those things are usually sent to the trustee ahead of the hearing. So when we get to the hearing, usually the trustee has already reviewed documents and is familiar with your case if everything's been handled appropriately. And the typical hearing, you're really talking lasting 5 minutes or so. If you have a bankruptcy attorney representing you, like in our case, we will actually sit with you during the hearing and we'll help you through it and make sure that everything gets covered appropriately and that your interests get looked out for. Once the hearing has been held, in most districts across the country, you don't need to go to a second hearing unless some issue comes up in your case. There's a 2-month waiting period to see if any issues come up. If your case has been properly handled, usually the bankruptcy attorney will be able to tell you if you have any issues to be concerned about as you're going through your case. But if any issues do come up, they can be addressed. Just because someone objects to your case for one reason or another doesn't mean your case is over. It can be resolved, so that needs to kind of be worked through with the assistance of your bankruptcy attorney. But 90% of the cases, or so, even more actually than that, at the end of the 2-month period, no issues have come up, and the court will simply move forward and send you a discharge. That discharge is kind of anticlimactic. It's a 1-page document with 1 line written on it, typically saying it appearing to the court that you are entitled to a discharge. Your discharge is hereby granted, and it's not even signed anymore by the bankruptcy judge. It just has a /S/ and the judge's name signifying the judge's signature. That document, even though it seems very insignificant, is a very significant document because that's essentially your proof for the rest of your life that any debts that were incurred before you filed bankruptcy that they are not allowed to collect from you. It's a court order and an injunction stopping any creditors from trying to collect any of these debts from you. Now, one last thing I want to raise here is just because you've received your discharge does not necessarily mean that your case is over. Your case has to be closed. If there are any assets that remain that the trustee is reviewing, those assets may still be administered and may still try to be sold or get some kind of value out of them to benefit the creditors even after you've received your discharge. So really the key that you need to be looking for is to make sure that your case has been closed, because that's when really your case is over for all intents and purposes. Again, these are the types of things that your bankruptcy attorney can help you through. If you live in in southeastern Michigan, feel free to give my office a call. I offer free consultations. My office number is 586-693-2000, and our website is financiallawgroup.com.